Okay, without further ado, ladies and gentlemen, I give you Attorney Christina McPhail Stockdale.
Thank you, thank you. Hi, everyone. Thank you so much, of course, for having me, ladies. It's always an honor. I think back also to my affiliation with this organization actually prior to starting law school when Judge Thomas was serving as president. I'm talking dating myself, but this was we're going back into like the late '90s and 2000. I was able to join even before actually enrolling into law school. I had the opportunity to be able to network because it was an interest of mine, and so forth. Christina Hurd was a big part of that with Christina Law Street now. But so thank you so much. So let's get into the meat of this. Actually, growing your cannabis practice. It's a very interesting industry overall. I'm sure you all have heard. It's not only locally, but nationally. This is a billion-dollar industry. The reality, however, it is that those billions of dollars do not come our way. Not because we're not huge stakeholders in the industry. We don't have ownership interest in the way that we should in an industry that prosecuted us and disproportionately criminalized us for decades, and during obviously your war on drugs. But as vendors of services, we're not used as the architectures for build outs. We're not being used as counsel on the negotiations of contracts or the merger and acquisitions of different cannabis companies. We're not included in construction bids and so forth. So we're seeing now a huge shift into that because now diversifying this space, not only just with us as counsel, but us serving and wearing many, many hats in these types of business and organizations has now paved the way for us to participate and be better advocates, not only for us to be able to represent these types of clients, but for our minority or women clients to be able to have a seat at the table, and of course be profitable and hopefully establish generational wealth in this industry, which it is. So I want to first talk about how and what is cannabis law. Don't think about it as so unique and specific, which it is to a certain extent, but just like any other industry, it's a business. And if you're interested in getting into this, I would definitely suggest that you just kind of merge it into the umbrella of your normal business practice law. So if you're already in a civil practice and you represent certain business clients, and you're serving either staff counsel or in-house counsel or what may have you, the needs for any other industry are the same needs that the cannabis businesses need. There's a lot of regulatory and compliance, yes. Well, simple things such as certain standard forms they may use to be able to interact with clientele or to conduct their daily operations. Incorporating their businesses, making sure that they're in a position to do proper accounting, taxation. These are the things that we look at for each and every single business. So again, the industry itself is like any other business needing a series of different things. Now, this umbrella is a huge umbrella. The next thing I would indicate and suggest to you if you want to do this is to find your niche. What would you add and how would you help cannabis, commercial cannabis client, as well as a individual independent operator? Now there are, as you may know, several different types of businesses. We have cultivation, those are the grow facilities. We have the retailer, which you'll commonly hear as the dispensaries. And under our Michigan law, we refer to the medical dispensaries as provisional centers because of the medical compliance part. And then we also hear recreational adult use, which is essentially not necessarily having to have a Michigan medical marijuana card to be able to engage, purchase, or indulge in cannabis. And with respect to your municipality, there are certain rules as to how much you can actually hold for possession for purposes of the recreational law within your home and so forth. But find your niche in this. For example, if you have a background in compliance, you're used to maybe dealing in bankruptcy or IRS code or telecommunications, that is definitely a major need for a compliance officer and being the compliance coordinator for your respective cannabis client. Compliance is huge because if you're not in compliance with the commercial law or the medical marijuana law that deals with caregiver and patients, then you're under the criminal penal code. And your client's compliance is necessary. We don't want to necessarily see our clients be unfairly prosecuted or have their licenses stripped away. The appellate process to obtain a license back is very difficult and it's costly. So what is your niche? If you're not into compliance, if that type of thing is foreign to you, understanding rules and regulations, maybe that's not the way that you advocate or represent your client. Maybe you're more into dealing with structure, business structure, helping them to ensure that they're benefiting financially from the right type of corporate structure for taxation purposes. And that's very unique issue as well. I personally don't do taxes. I'm not a tax accountant by all means. I refer my clients to tax accountants I work with, but it's very important that I have an understanding enough for when I structure their organization, or I understand that if we do something such as a simple LLC, but I may convert them to an S corp later on, and the purpose and the reason as to why we're doing that. So again, find your niche. Sometimes as an advocate, it's not necessarily dealing with the regulatory compliance. It may be doing something with legislation. I had the opportunity, fortunately, to draft and write social equity pieces for various cities, and even provide a module for the applications that get used in certain cities, for the applications for individuals to apply for. So if that's your niche, if you're used to being able to present and advocate to your local municipality, your council, what may have you, as to whether or not your client should be able to do this, then perhaps that's the way you get in real estate. It's important that with the transactions of buying commercial real estate that's zoned specifically for this business, that you understand that it's not just a regular real estate transaction. And I know that some of you in the room have that real estate background. We have to ensure that the special land use is also that runs with the land, but in cannabis is also unique to the applicant. So for example, if a city has capped licensing and they're done giving out and distributing and awarding licenses, now your client decides, you know what, I'm gonna sell, or I'm going to buy additional land. The city is not gonna allow a new applicant to come in. They have to kind of do it more like a merger and acquisition. So in other words, your client is not only buying the real estate, they're gonna buy that LLC, they're buying the entire company and its assets as it relates to them to be able to operate. And then you have to go forward with updating your local municipality, the city clerk with regards to those changes, with regards to who are the new principals under that same LLC. And then you have to do the same thing at the state level. Eventually you can do the name changes and so forth, but and the city will lax on that. And some to lax at the beginning, but to avoid the accusation, oh, you're awarding more licenses, I thought it was closed, you kind of have to be a little bit creative. So again, find your niche. I'm a little bit spread all over the place. I've done all of it. I've even done litigation, which was related to federal constitutional question about Detroit's first ordinance, whether it violated the Commerce Clause or not. Most of my work is transactional. I think now at this point in my career, that I prefer not to have to be in court as much unless for select issues or things you need for clients. My work is highly transactional. And then there are those that love to litigate in this area. but be prepared to have to litigate for your client, or have good standby counsel who can handle the litigation and understand the issues for you, who would be willing to do that. You want to be, of course, provide cost-saving measures for your client, but then just sometimes that's just the unfortunate reality of when you do represent these types of clients, you end up being the attorney that does a little bit of everything for them. You may outsource some of the work, but the likelihood is that the clients are very attached to you, they like you, and it is a unique clientele. So that gets me over to the next issue of generating clients. Now that you understand, okay, what my niche would be, I do want to add this to the business area of my practice. How do I generate clients? How do I get them to come and hire my office or utilize me? That is where you come in, making yourself available. There is some marketing involved. I'm not talking about necessarily advertising on television or flyers. More so a lot of social media, reputation, traveling and being a part of different organizations. All of you are no stranger to this because these are things you do for your other areas of practice. Cannabis is a little bit unique because the clientele, some of them are weed heads. So you're gonna be around people who want to talk to you about cannabis, and you have to understand it. The verbiage, you really need to start to understand how weed makes money. You should understand the growth cycle. You should understand the rotation and the cycle of a harvest, how much weight per pound. You should understand the conversion, especially if you're attorney representing clients on drug offenses. You should know the conversion between pounds, ounces, and grams. You should understand the value. You should know the difference between flour and a tincture or an extraction, Rick Simpson oil, gummy, edible. You should know the difference between low grade and premium grade. And I'm a non-smoker. I'm actually very conservative and had conservative feelings about marijuana. I actually don't like the smell, but I get it. And my clients, I was open-minded enough where my clients helped me to understand that. A long time ago, when they initially introduced in 2008, initiative for the legalization of medical marijuana, I read that statute and I saw all the holes that were in it that needed to be changed. I actually voted against the legalization of medical marijuana back then. But it won. That was actually a year that we voted for the first term of Obama. So it was a huge turnout. And of course, the voters spoke to want to have something in place for medical cannabis. But very shortly after, there were a lot of people out of compliance. So it didn't decriminalize cannabis in the manner that it should have. What it created was for some counties' prosecutorial policy, the scapegoat, well, I can't get you for possession, but we're going to charge you for improper transportation of your marijuana, which is a misdemeanor. So they were treating marijuana like it had to be carried in the back of your trunk like a firearm. That was not the law. And the Medical Marijuana 2008 Act was very clear on that. It took some time for that issue to finally get to our Supreme Court. And even though they did think that was unconstitutional to do that, it didn't have retroactive treatment. So then you had a bunch of individuals, unfortunately, that had misdemeanor offenses on their record, which we all know in the minority community, it creates hardships for employment. Fast forward now, we're 15 years beyond our initial medical marijuana approvals. The cultures are different, the attitudes are a little bit different. So in generating clients, you may sometimes have to go to their grow facility or their retail store, but that's good so you can get an idea of what the space looks like. You should be able to know if they're in compliance or not, if you're going to be a compliance officer. This is not necessarily sitting behind a desk and talking to clients like we see in maybe different types of industries. Cannabis can be unique in that realm. I would encourage, if you're going to do this, you want to have relationships with people in different cannabis businesses, be visual, participate not only at the bar sections and so forth, but there are various 420 friendly events. For me, I kind of leave obviously when the smoke is too much, but at the same time, they know me, I'm there, and they listen because they do need representation from us. I would also encourage having very friendly for social equity applicants and as well as for independent operators, have maybe friendlier fee terms, or payment arrangements that make sense for the level of work that you're going to do. It is a lot of work. So I'm not saying to price yourself short, but the way that you would tailor fees for certain clients, commercial and individual clients, I would again indicate that same practice should be employed when it comes to the cannabis area. Let's talk about the scope of your representation. Be very clear on that on your engagement letters. A lot of times, just like any client, this has to be a licensed, regulated entity. So a lot of clients aren't properly ready to be able to engage in this business. That's just the nature of this beast. It's very expensive. $1 million easy to have a retail store open. So they don't have that kind of money. You're finding yourself doing joint venture contracts and agreements with other investor agreements, which requires anti-secure fraud language and so forth. So you're dealing with securities. So it's important that you outline to your client so that, and this is an ethical issue as well, is to ensure that you're outlining what the scope you're going to do. If there's something you're not comfortable with as counsel, that's okay. Have that conversation with your client and bring in the attorney who you do know that can maybe help you in that regard. Make sure your client understands that, okay, I'm going to incorporate your business and do this, and they don't think that also means you're going to give them the funding to be able to do the business. That's two different things, obviously. So make sure you're clear with the client. A good, clear plan of communications with any client, of course, is a number one rule that we have to abide by, and it doesn't change for cannabis. The forecast of the business. I'm sorry, the forecast of the business. The market has changed significantly with regards to Michigan, and it continues to change as new states are coming into the market. Be always conscious, aware of what that means as far as for your client's sustainability in this market. It would also an indicator of the sustainability for this area of practice to continue to grow and for us to do what we need to do. Again, I mentioned earlier that the price point of product has changed, so you should be aware of these things. Our state bar, the Cannabis Regulatory Agency, is a great resource on their webpage for information. Some of these things can be done through simple Google searches. Not only am I doing this type of work in Michigan, but I'm in other areas, other states doing the same thing. Getting ready to work with some international clients as well in the scope of cannabis. And so it's really important that we kind of understand what's happening in the market, just not abroad and nationally, but then domestically and locally for us, so that you could be able to better help your client. The last thing I wanted to point out is staying updated in the law. There are administrative updates all the time. We have our regulation of the rules that actually say what you can and what you can't do. And then there are various opinions from the Attorney General as well as from the CRA as to what you can or cannot do. And then there are administrative laws that further speak about what you can or cannot do. So there's a lot of regulation that you do need to be updated on, even if you're not the regulatory person. If you have that intern who's great at writing memorandums and to try to update you, keep your office updated in that regard, that's a high value. At the end of the day, that's what clients are retaining you for, is to be able to provide insight to rules and regulations. I'm human, sometimes I don't keep up with all of them, and I, have to tell clients, let me double check, I'll get back to you on that. And that's okay to let, of course, your client know that you have to research the issue. You don't have to be a walking dictionary with regards to the cannabis area. And then that's generally it. So that's just kind of a broad scope of this practice. It's very interesting. As Black women, there are only so many of us in the state that are doing this. One of us is in our panel now, Tanisha Davis. She blessed us with her presence, of course, always, on what she does with this group. And
Hey, Christina.
hi. There's Roma Thurman. There's a couple of others. Renee Jackson. There's only a few of us, but and Tanisha can indicate when we go to these functions, we go to the state bar, there's like 3 of us. and then when we talk about the Black men in this, there's only about 3 between Martin Morris, Jerome Crawford. There's only really about 3. And so I would say overall in the state of Michigan, maybe women and men, there's probably only about 6 Black practitioners doing cannabis, and we have to encourage the clients that, they can come our way, but they don't know about us, so it requires some type of visual. Now, some people they have their client, they work with an MSO, which is means multi-state operator, and then that's okay, that might be the way that you go if you're used to being corporate counsel. And then if you do what I do, where you represent and advocate for many individuals, it's important that we're visual and you do what's necessary to be able to do some outreach and make sure that they know about you. I participate in radio discussions. I come to community events that push for social equity. And I use that word a lot. Social equity, for those of you who don't know, is our state mandated program that looks to, again, diversify the cannabis market. It targets, it's supposed to help individuals who live in municipalities that were disproportionately prosecuted because of the war on drugs. So there are 184 communities that our state recognizes as social equity communities. So it's Detroit and even Ann Arbor. So whether or not you're representing a client that's deemed a social equity applicant or client, understand what's required, understand what's needed. Many of these individuals don't have the money. Sometimes they have the money and not the real estate. Sometimes they have money in real estate, but not the bandwidth to really do the business. There could be a couple of things there. So it requires a unique approach to their representation. I'm going to stop it there and move it for some answering questions.
We do have a question in the chat.
Okay, how do I open that?
Well,
So
it's
we
right
can
there.
just read
Oh,
it from the
okay.
chat.
Does Attorney McPhail offer advice on brand protection, specifically logo and trademark registration for cannabis businesses? And that's from Attorney Tracy Martin.
Yes, we actually do. Thank you, Ms. Martin, for that question. My office does get into discussing brands. Am I muted?
No, you're fine. No, there was just an echo. Don't just-
Oh, okay. If there is attorneys that do trademarking, definitely cannabis branding is huge. Branding is very important to actually the industry and to earning monies. That is a huge area of practice. If you're a brand specialist, you know how to brand for your clients and you're already doing it in certain areas, then the transition to doing this for cannabis clients will not be difficult. Purchasing weed is no different than when we pick designer jeans. Some people don't mind your, old school Walgreens brands, your Jordache. And some people want, Christian Dior jeans. I mean, it just depends. Well, weed is similar. If it doesn't have the reputation, if the packaging doesn't look a certain way, people go to what they're used to. In the dispensaries and in the stores, it's useful where the budtenders kind of help to be able to promote.
Did you say
brand.
bartender?
bud tenders. Your bud tenders are basically your retail clerks.
Like a bartender.
Yeah, like, it's a play on the word bartender, but essentially your bud tender is someone that should be knowledgeable, in a retail environment. Whether it's a provisionary center, medical or recreational, and telling someone about the product. Specifically, we're talking about flower. So you may have someone who's interested in having an indica or sativa. You should know the difference between that. I won't get into that now, but you should be familiar with the types of weed. Some people want something that has a certain type of aroma. I was at in Harrisville, up north Michigan. I went into a dispensary, and the bud tender there was telling me about how they had a new product. It kind of had like a blueberry essence to it, you know. So sometimes people who are like weed connoisseurs are into some of those flavors and aroma, but they won't know to try it unless the branding works and if someone's there to kind of help them to understand the brand. When you've seen about celebrities having a strand that they're promoting their genetics, it is a part of branding. You know, so that is important. Whether the product at the end of the day is a good product or not, obviously is left to the consumer, but branding actually leads them to actually purchase. And that's huge, especially when they're launching a new brand. So but trademarking that and the brand part of it is an important piece. We have a question right in here. Dr. White, sorry.
Yes. So do you think it's better, as far as profitability, navigating the legal terrain to be a cultivator or a seller?
If I may just provide a summary to your question, is it better to get into cultivation or to retail? Okay, my personal opinion on that, it kind of depends. But I lean towards definitely getting into manufacturing. Without good product, you don't have the industry. You can't have the retail in unless you have the manufacturing part. I should disclose also to this group that in addition to me being an attorney, my husband is also a cultivator grower. He's an engineer graduated as an engineer from Western, but he's actually a licensed grower. And we are building a facility out in the city of Inkster. We anticipate cultivating 10,000 plants. That's our business plan. It's a 25,000 square feet facility we're growing. Being minorities and access to cultivation is important because we can then have direct point of communication and contact with retail. For cultivators, their direct point of sale is not to the consumer. We deal with the retailer, so we're dealing with other commercial entities. So you would then indicate, you'll see at that point that depending on what the retail store needs are and what they need to do to bring people into it, branding, which is huge, and that is going to be good product and that deliverables are going to be met. A lot of times when you go to a retail store and they don't really have a lot on their shelves or it doesn't seem like they have this product, what growers are they working with? Who's coming to put product on their shelf? So my opinion, and I don't know if it's biased or not, I would recommend these what we call vertically integrated. Vertical integration involves not only being able to be the manufacturer, processing, which would mean take what's being grown and then being able to convert it into edibles, breaking down a certain flower, other type of derivatives and so forth from marijuana, right, blends and so forth. And then you have your retail store and then you're selling what you've grown to the product. That requires, of course, capital, requires the opportunity to have the right land and so forth to be able to be vertically integrated. But that will be a goal, especially for individuals who want to become licensed or invest with an existing license fee. I would definitely reach out to one that's vertically integrated, being able to manufacture and sell legally. The other one is criminal, we call that PWID, right?
Right. Okay, Tanisha has a question. Tanisha, do you want to unmute and ask your question?
I just, Christina, can you talk a bit about the challenges of banking and, for cannabis companies? Because it can lead to other areas of law that people might think if you have a finance background or you do taxes or you do anything that could assist a cannabis business, there are some issues there that also need to be addressed in many different areas. So Christina, can you talk just a bit about that?
I sure can. The problems with banking. Here's a unique fact. Okay, so we know that, bankings are typically federally insured institutions. And they typically follow a policy to not want to deal with any type of entity that then is not recognized federally. Now, even though the states have sanctioned the legal sale of cannabis at both for medical purposes between caregivers and patients and then at a commercial level, federally is still not recognized. So the banks tend to follow this rule or this practice to not want to. But when you actually read the insurance policies, the FDIC policy agreement, it doesn't say that they can't accept the monies from a cannabis institution. So cannabis companies actually face the problem because they tend to be a cash business with these restrictions or being limited to be able to bank like the rest of us they can. Where can you bank? My suggestion is to structure your company in a way so that you can still bank legally. Many times you'll see holdings company. A holdings company can have multiple things. It can have a commercial building for multiple apartment dwellings, right? And then have interest in a construction company. And then it can have interest in a cannabis company. But its primary business is not cannabis, it's a holdings company. So what you tend to see is sometimes a holdings company that serves as the parent corporation over everything else, all of its dealings, that's what banks. And they do it so forth in that way. Now there is somewhat a debate between whether they're engaged in some type of criminal act or not. Of course, they're not. It'd be no different than for us attorneys who represent clients that may not necessarily be doing the best things, but I don't ask where the source of the money came from, and I'm not obligated to, ethically or legally. And my client pays me, so if I bank and then all of a sudden my bank asks me, did you get that money from a dope client? How dare you? So that's where I see holding companies in the same decision, because their principal business is not cannabis. So that's a way to kind of bank. If some of the banks, they may or may not know, they won't question it that way because their form doesn't require them to do it. Now there are banks in Michigan that charge you higher fees, but that do allow you to bank. One of them is out of Grand Rapids, known as the GW Bank. Why is it called GW? But it's like GW Bank. They will actually come and pick up the cash using transportation, a licensed driver's. Transportation is actual license that you would get in the cannabis, in our state under the cannabis regulation rules, and be able to pick up money from wherever you are and be able to bring it to the bank. So you're depositing, if not $100,000 or $40,000 in cash, they charge fees for that, but they will accept your money because there is no law that says you can't bank. It's just a preference of the banks. Hopefully we would look for some more 420 friendly, more cannabis friendly type banks. Flagstar, I understand, is kind of on the rise to be able to start working with some cannabis businesses, but it's still an issue.
What about credit unions? Are there credit unions that were more?
Credit unions are the same problem.
Same issue. Oh.
Same issue. Sometimes if you think about maybe a People's Credit Union or something that is a state created credit union, they tend to follow the same rules sometimes as a bank. It's almost like a don't ask, don't tell policy. At any time, if they have a suspicion that you're a cannabis company and you want to bank with them, they'll just shut down your account, tell you, here's your check, give you back your money, we're just not gonna bank with you. But we don't really want a paper trail of that because that's to hinder you from banking somewhere else. When other banks may inquire as to why an account may have been closed. So there's still a bank, our state legislatures are working heavily on this, and even at the federal level, they're looking at this as they start to look into changes to how to treat the decriminalization or deregulation of cannabis at a federal level. But as it is right now, it is a problem. So I would encourage lawfully to get creative for your client to be able to bank. A holdings company is one way to do it. Don't bank with company names that say like, you know, we got the best weed, or, you know, we got that shit. You know? The names are part of the branding and the marketing. I get it. When you come in a bank with it, don't bring money.
Don't flash.
Wow, with weed, you know, don't go. It is what it is. You know, while the culture has changed in regards, there's still some stigma, some tabooness with cannabis. You know, I myself used to not talk about what I was doing when I was representing cannabis clients because I was concerned about some type of backlash. But when I started opening up and talking about it, people were more intrigued with it and had questions. And I use that as teachable moments, you know, to talk about that this isn't some hippie trap house operation. It's a very sophisticated operation. So that's what it is. So I hope, Tanisha, did that address your question on the banking issues?
Absolutely. Thank you.
I had a question in terms of the holding aspect that you were discussing. Is that you, the individual, like business owner, would have to present to a bank multiple businesses that they own, or is it the banks?
No,
It's a company.
It's
They have
multiple.
multiple companies that they.
They don't ask that. You're just applying for an account for Rita Holdings. That's
Okay.
it. And you don't have to quote what Rita Holdings has multiple vested interests in. Rita Holdings can have stocks, can have other vending machines. No, you can have other types of businesses under Rita Holdings, and it is one of them. This happens to be, it has a vested interest in a cannabis company.
Okay, so what if the company does not have any businesses? Would they still be legal to state?
So if the cannabis company was its sole entity at the time,
Correct.
same issue. No,
Okay.
it's a holdings company, and you're not doing, your business isn't held, isn't doing the cannabis operation, it's the other entity. It's the same thing where, the purchase of land. I would never, and this is for anybody who's looking to buy land or zone land for their cannabis company, don't purchase the land in the name of the cannabis company. Do it in the holdings company. The holding company is the owner, the landlord. It's able to move and do things that the cannabis company is limited in being able to do. Charge the cannabis company rent, and if it's your company, you rent that way. So you can get deductions over that way of rent, which you can't get at the cannabis company because of IRS Code 280, which has been the problem because of this federally criminal or the enterprise is a criminal enterprise or illegal enterprise under the federal government. IRS Code 280 is where we would get our standardized deductions. So you can't itemize for employees with certain costs or things. So how do you convert and do those? I've seen some of my companies, client companies would outsource their employees as contractors through a third-party cannabis staffing solution company. So where they can't get the write-off for the employment, but the staffing solution can. And sometimes if they both own the staffing solution, then you get the write-off here where you can't get it here. So use very creative, like, and then obviously you don't have to claim the unemployment insurance and workers' comp if you keep your paid employees under a certain number, you know. So there's a series of different things to get creative as a cannabis company that you can do for your client, depending on the size or what their needs are, their expenses. And that's where you have to start familiarizing yourself with the rules and regulations. You end up kind of being your general counsel for clients, wearing many hats, practicing and dipping in different areas of the law. I think water starts to get too deep. Of course, you're bound inevitably to bring in the specialist.
And what motivated you to get into this area, like, in the first place?
Well, because I had conservative values, I just didn't like the way that our white counterparts could move, doing the same thing, and then essentially we couldn't. Clients helped to change my mind too. This happens in many ways. After the 2008 inaction of the Medical Marijuana Act, I had a client who's HIV positive without insurance. So he didn't always have access to the meds. He didn't have that type of help, and his Social Security didn't kick in yet. So some days were painless days, and other days weren't. And one day he got caught with a certain amount that was enough for a personal possession charge. The judges, and I'm sure you all are familiar with this, despite voluminous medical records that we presented, wanted zero tolerance, even though she knew he was HIV positive and uninsured. Fortunately, this is a case in how. First,
Oh, wow. Oh, my gosh.
Black guy in how. So fortunately, and he was gay, so I think he was just getting mistreated all around, but the probation officer was pretty cool. He said, you know what, if his levels don't go too crazy, I'll let lie. He told him to get that medical marijuana card, but the judge specifically said, I don't care if you have a medical marijuana card. I want zero tolerance. I had a problem. There were a lot of judges taking that position. There were a lot of judges that didn't want to invade into the certification that doctors were providing patients because they just didn't believe that your person had pain or whatever. So
I think they just call and say you need to have the doctor appear in court.
yeah,
And verify that they checked everything out to say that they should have medical marijuana. Like,
Or something.
so the problem with that is then you had individuals that would then just go ahead and do the plea, get stuck on probation, and we know once you're on probation, and it's subject to being violated, and then the cycle continues and continues, now you're looking at guidelines that put you in jail, so the mountain out of the molehill problem, right? Yes, Rita.
Yeah, there's several attorneys on the screen that practice at the child welfare area, where I have clients that they have their children removed, their children removed based on maybe some marijuana issues that occurred to bring the petition in place. However, as the case moves forward, they've obtained housing, they have income, et cetera, but they keep testing positive for marijuana, and the courts don't want to reunify them with their children. Do you think, given your experience, do you think the law is going to start moving towards eradicating the stigma of people, parents, families, people that are charged with cases being just hit with these marijuana charges or allegations based on the fact that marijuana is legal, but they're still trying to use this against families to
some of the judges are starting to get it. They said, okay, if all the legal parameters are in place, I'll permit it, but I don't want it done in front of the children or something else, okay, we get that part. And it just requires more advocacy. You have to advocate for your clients on the record. You have to make that record. I just had that case the other day. My client definitely has an anxiety order, and out of warrant, the judge wants them to drug drop because it's a case involving another type of controlled substance possession. But my client does have the medical marijuana card to smoke, and so the judge just wants them to make sure. I want to test it because it's a controlled substance charge, but as long as he's in compliance with this, I won't violate for the presence of cannabis in his system. The judge gets it. So okay, that's something that he shouldn't, zero tolerance is a problem depending on what it is. I think it deserves more of a case by case analysis as opposed to just a blanket approach. And that's the problem, just in general in the cannabis spectrum. Many of our fellow judges in 36th district take the same approach, that they're very conservative with regards. They don't care that you have this or have that. They just have their personal opinion about marijuana that they're bringing into the courtroom. And my thing is that I'm not here to change your mind. Well, follow the law, and the law says they can do this. So when you're punishing them for being in legal compliance, whatever your personal issue is, Judge, that's inappropriate to be applied here. And then attorneys, we know these judges off the record, so, they're our friends, our colleagues, but, you want to respect them, of course, in the court and not be held in contempt as counsel, but if you don't push the button, respectfully, of course,
Right.
to let them know, at least that, Your Honor, may I please make a record? And I'll say my piece, and as long as you did that, I made a record, so if anything comes up, now I have something to be able to, use forward for a motion if I have to, or something, anything or everything, if I have to require any type of, appellate review or whatnot. And it's just being an overall good advocate. So this is where we see the practice of our cannabis law also flow into continued litigation. Very serious. Yeah. I think there's another one. Oh, okay, I'm sorry. Is there a question on
Well,
this?
there's- you can take that question.
Go ahead.
Oh,
What
okay.
is another question?
Is there another
Tracy
question?
Martin says Megatron, AKA Calvin Johnson. Specifically, Tracy, what are you referring to?
Okay, that was just, thank you, Delicia, a comment, when Attorney McPhail was talking earlier about celebrity branding. And I understand that, well, actually, a friend of mine works closely with Megatron. And I understand he's got 250 acres for cannabis production. And so does he have any particular type of celebrity branding that he's got going on? And do you know who's representing him?
I don't know who his attorney is per se, but okay, so Calvin Johnson and Rob Sims, they're both former Lion players. They have a grow facility in Niles, Michigan, known as Primitive Cannabis. And then they do contracts with, where their product ends up in various stores. One of them was with Jars. You should know the name of Jars because Jars is one of the organizations challenging the city of Detroit's new ordinance because they feel that setting aside licenses for social equity applicants is somehow unconstitutional. So Jars is not really on my good side. Now, whether they still do business with Jars or not, or other dispensaries, but yes, to overall answer your question, they have a brand, they've been marketing it. They're very, very present in social media. Tanisha and I, Tanisha wasn't there, but Rob Sims was just there doing a presentation at the annual conference for the Michigan Marijuana Attorneys Bar Section. He's very friendly, very approachable, and he actually talked about the road to actually getting from interested and in the cannabis, trying to do it in the trials and tribulations that they went through. At one point, they were denied licensing because of parking violations out of Atlanta, Georgia, that one of the players had. So those were the kind of things that they had to deal with very early on before the licensing entity, what was the MRA, now the CRA, when it had a panel, but Governor Whitmer, thank goodness, got rid of that panel. And now we're dealing with a different approach to how they evaluate these licenses. But yeah, Primitive is the name of theirs. I wish them much success in that. They're a good group of guys trying to take advantage of the cannabis business as minorities in this. We're only 3% ownership nationwide in the cannabis entity. So I hope to see them progress and do well. And they're doing it on the west side, kind of west northern side of the state.
What is Jars? I'm sorry.
What is Jars?
No, I know what Jars
Oh,
is, but
What is
what
Jars?
is their?
It's a retail store and they have different ones, medical provision there. They're licensed dispensaries. Yeah.
Oh, and my question specifically in regards to the social equity aspect and the issues with that, across numerous areas of law, we know of social equity issues. So what is their basis saying that, they have an opposition to social equity and inclusion aspect of the law?
The problem with the social equity issues that they have is it goes back to the state has a social equity mandate that says you have to live 5 of the last 10 years in a social equity city. And you get a discount off of a licensing fee when you apply for licensing, as well as when you actually get a license for a space. They direct the cities, however, municipality to adopt their own social equity program. Each city could say, okay, we're gonna take social equity and we're gonna do this. We're also gonna do this. We're also gonna do this. So the example is with Detroit, obviously, is Detroit had a social equity program kind of on steroids. Not only are we gonna, we're going to take the social equity mandate, we're gonna extend that 5 years. We wanna say you have to have 10 or 13 or 15 years of being a resident in our city. In addition to that, we'll help you get land. In addition to that, we'll waive your fees. And in this, they were trying to bring in more Detroiters into the market so that they could have a space here, because the current licensees, let's say, for example, the retailers, out of, at that time, 50 licensees, 46 of them were non-Detroiters.
Right, yeah.
So the law got challenged, indicating it was a violation of the Commerce Clause. That is, it was essentially a restraint on travel, because when you take those type of residential requirements or residency rules, you're indicating for everybody else that can't participate, and that's somehow a violation of the Commerce Clause. The city and myself, I intervened in the litigation representing an amicus curiae, several different Detroiters and individuals, companies, and I represented their interests in that same litigation. The argue is that the Commerce Clause is invoked when we're talking about interstate market, but because of the federal illegalities, it makes cannabis an interstate market. So really that and other issues kind of made cannabis unique and not necessarily something that made the Detroit law unconstitutional. The judge's approach was that he found that cannabis was an interstate market, despite that the state website regulating cannabis said it was an interstate market. But that Detroit went a little bit far. Fix the statute. Detroit did fix the statute. They took they stripped away the opportunity to help use land. They stripped away giving you a conditional license if you didn't have everything for the most part. And then they just pretty much said, we'll just take the social equity mandate. 5 of the last 10 years. This opens it up for the other 184 communities to also now apply, no different than if you were a Detroit resident. What Detroit also did was we're gonna set aside 50% of the retail, there are limited, some licenses are unlimited. Like, it doesn't matter, for grow facility, we didn't cap those licenses. For a transportation, someone who's gonna be transporting products and so forth, we're not capping the licenses, the issue. What we are gonna do is cap the licenses for retail stores and for micro businesses, which is pretty much a mini version of the vertically integrated model. So we're gonna set aside 50% of the licenses for social equity applicants. That means that now 183 communities can compete with Detroiters for licensing. And then the other 50% will reserve those for general applicants. We don't care where you come from, out of state, in state, whatever, you can apply. They're suing because they don't think the 50% set aside for equity applicants is fair. They feel it's a guise of doing what the first ordinance did, giving preferential treatment to Detroiters. So now it's back in federal court. The first lawsuit has been dismissed because Detroit changed it. There are no TROs right now. So that lawsuit was filed a couple weeks ago. The time to file an answer has not yet told. So we'll see how that goes. I'm supposed to be getting notice as the amicus curiae for the judge said, going to give me notice too. Whether I decide to litigate this time around again, I don't know. That is what's happening. We had a state lawsuit that was filed, same thing, because they have 6 medical dispensaries. They want 6 of those retail licenses. So it's unfair to set aside licenses in a merit-based application system for a particular group. But the judge has sided with Detroit and said, no, you know, that's not what this is. In other words, you're asking us to reserve 6 licenses for you. We're not gonna do that. They argued there would be equitable harm or whatever, because we have 6 and we need them for all our stores to be recreational. No, there's a limited number of licenses here. They're opening it up for everybody. 50% and 50% isn't inherent unfairness. And then it's gonna be a lottery pick beyond that, so it's not, but they're just reserving 50% for those who are pulled out from the lottery pick. That's getting challenged as well. So this is where we are. So this is a fight really against diversifying the marketplace. They do not want us to be license holders. They do not want us to even have a vested interest. They want it to be very minute. And somehow, some way, they don't sue their communities for opting out, but the communities like Detroit that opted in, they will sue to get their licensing. And so this is the problem. We don't see them suing Bloomfield Hills to say, I want to be able to have a store right here. They don't do that. But they will come to Pontiac, they'll come to Detroit, they'll come to they'll come to these communities and do that, threaten everything. It happens in Easter, so this is the plight, so.
Okay, well, we got 1 more minute. Do we have one more question? Okay, Dr. White, that's another question.
Where can we find the specific requirements for licensing? Like the
Oh, this is well published, it's well published. It's,
Which website?
yep, the CRA website, which is the Cannabis Regulations. So it gives you everything, and then, look at whatever municipality that you're thinking about doing this in, look at what they require, assuming there's licenses still left.
Okay,
All right.
all right. Well, thank you, Christina. Let's give her a round of applause.
I hope that was helpful, everybody.
Yes, very. Thank you, everyone. So we've got our next meeting. We've got Tracy Martin's gonna come in and talk about how to handle a neglect case. And so just stay tuned, look at the email. Let us know if you have any questions. I also want to point out too, I don't know all the candidates per se that are African-American for the judicial race. So if you know of any candidates, email me so I can make sure to include them for the virtual judicial meet and greet on October 23rd. So thanks, ladies. Everybody have a blessed day.
Bye-bye.
Later.
Formally close. Yeah. That's that. Do you formally close?
Yeah, we were supposed to close the.
I make a motion to adjourn the meeting and presentation.
Is there a second?
I'm with it.
All in favor?
Aye.
Bye.
Thank you. Later.
See you guys later.